All right, we now call 23 CR 1490, the state of Texas versus Joshua Booker, who is present with his attorney, Mr. Wilkerson, and the state's attorney. Does the defendant waive a formal reading of this indictment here? Can we proceed in summary?
He does, Your Honor.
All right. In summary, Mr. Booker, this indictment alleges in paragraph 1 that on or about December 1st, 2021, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here?
Yes.
Okay. Because the child was younger than 14 years of age, this becomes it's referred to as a super aggravated first-degree felony, which means the punishment range is enhanced from not less than 5 to not less than 15 years imprisonment, up to 99 years imprisonment or life imprisonment. Do you understand the punishment range applicable? And I guess as well, a fine up to $10,000 could be assessed, but that's not going to be of consequence in this case, correct?
That's correct.
You understand what you're facing here, sir? Yes, the gaps with you. That's nice, lady. Can hear you. All right. The agreement's been reached where you would be pleading guilty, sentenced to 45 years imprisonment. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty, sir? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true at state, so help you God. Is that true? Yes. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived?
Yes, Your Honor.
Sir, I'm going to follow this agreement. If nothing further, I'm going to find you, Joshua Booker, are pleading guilty to this aggravated sexual assault of a child as indicted in 23 CR 1490. You were doing this voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 45 years. Do you understand what has happened today, sir? And you will be given credit for all time that you have served in connection with this offense up to now. Anything else?
And Your Honor, just after the victim would like to give an allocution.
Okay.
And one more thing from the defense, Your Honor.
Yes, sir. Go
During
ahead.
the pendency of this case, Mr. Booker's ability to communicate with the outside world was restricted.
We start off, we've got 2 cases, correct?
Correct, Your Honor. Both.
And you are Caleb Landry?
Sir.
In 23 CR 908, the earlier case, you were charged with the state jail felony of burglary of a habitation on or about February 14th, 2023. And that carries with it no less than 180 days up to 2 years in the state jail. You'll understand if convicted.
I think you said burglary of a habitation.
I said burglary of a building, state jail, a burglary of a building,
Yeah.
not a habitation, a burglary of a building, which is lesser than a burglary of the habitation. It's no less than 180 days up to 2 years in the state jail. Burglary of habitation is a second degree felony. Do you understand what you're charged with here in this?
Yes.
And in 24 CR 2225, filed on October 23rd of last year, this states that on September 17th, 2024, that you committed the state jail felony of burglary of a building Looks like the same building owner. The victim is the same as the
It's,
previous case.
Probably discount tires, I think.
And it goes on to state that you have, in this indictment, you've been convicted in 2005, felony offense of illegal possession of marijuana, a state jail felony out of Harris County, Texas. And in 2015, you were finally convicted in the criminal district court here of delivery of marijuana. And that doesn't affect the punishment range on this, does it?
Yes,
Judge, Judge, if he's
Two
on,
prior state jail felonies on separate.
it adds to the third.
makes it a third
So,
degree.
well, your punishment range is in two things that are problematic. Your punishment range will be enhanced if this is proven true to what would be a third degree felony punishment. It's state jail felony, but it's punished as though it was a third degree felony under law. And you were looking therefore at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Plus, if this is true, you are not eligible for probation in either of these cases. Do you understand?
Sure.
Okay, that's should be a lot on your mind here. What are we going to do today?
You know, the state has tendered an offer of 12 months or 1 year in the state jail facility. And,
How much time does he have credit, if any? Please. Okay, go ahead.
and Mr. Landry's advised that he's refusing that. Is that correct?
Okay,
You don't
That's what you wanna do?
The state's offer.
that's what you want to do?
Speak up.
It's a hard decisions, but it's your life. Right now, we're at a crossroads. It's either going to go that way or this way.
And that we would-
Which one?
To be clear, one of the things that hasn't been stated, he is not eligible to receive probation from a jury.
I said that.
Should he Should he do that, I will, if he continues down that path, I'll withdraw the state jail offer and give the enhancement notice on both cases, so that they're both dealing with third degree. Sure.
Okay, it wasn't, yeah.
It wasn't included in the
indicted.
first indictment for some reason. We must have recovered them, by the time he alleged to have committed the second offense.
But he has 17 days credit.
Okay, not a lot.
Not a lot.
Let me ask something here. What's his bond?
What are your bonds? Each.
$5,000?
Each. Be probably 5 each or where I would have, that's what he seems to.
He's correct.
Okay. When was this bond posted? In 908? I'm looking at July 15th of 2024, correct? Is that right, everybody? That's what I'm seeing.
If that's right,
It's
then
$5,000
he's alleged to have committed the second offense while he was
in
on bond.
September. Yeah, we got a bond issue. You committed, according to the grand jury, and this second offense after you had been charged and in this earlier case, and you posted a bond of $5,000. Let's see, stand by. Looks like the amount of bond was fixed at $25,000 on July. I'm looking at another document that says July 20th.
He made the accusation may have run the initial arraignment may have been 20. I'm
There's a 715, a $5,000 on 7 that he paid on 715. But then there's a warrant for an arrest, a capious burglary of a building filed on July 16th. Okay. And the bond was fixed. Sums.
He probably got.
Says the amount of bond fixed by the court in this case is $25,000 here.
That was probably the initial arraignment. He didn't postpone.
Yeah, it was an arraignment.
And he got out on accusation after that, and the warrant popped up sometime after he was released on accusation, and the bond
But it's
On the
showing
one
5,000.
was set at 5.
Is that right? Lacey? It's showing 5,000 on this. Okay.
But he was arrested on.
And all of this was done though before it is alleged that he commits this next crime, 24 CR 2225.
He may have been out on the accusation on the second offense.
No, the second offense is on or about September 17th of 2024. All of this is July and July.
Which the initial bond he made in 908 was made on 7/15 of 24,
Yes. Of,
$5,000.
yes. Then what?
And then it looks like. Looks like the bondsman surrendered that bond when he was rearrested. And he made another bond. In this case, on 2/10 of 25.
Of how much?
The initial bond was.
No, I'm talking about the new bond.
Should have been 10 if there was an air for this.
It wasn't an AFR, so it was a surrender.
Oh, all right.
Is it showing it's still 5,000? Yes.
Yes, yes,
Okay.
still 5,000.
Okay. And then when did he post the bond in 24, 22, 25? The new thing.
10 of 25,
What was that bond?
5,000.
Yes. Well. On what day now?
2/10 of 25.
Okay.
That's after the.
Mhm. Yeah, that indictment had already been
Right,
prepared and has those prior convictions, and then you have that.
right.
It just slipped. It must have slipped by somebody. Um, See, on this indictment, here's what's, once again, I don't know how this is happening. On this indictment, on the face of the indictment, 7/20/23, that's me writing it. When I get the bond, I'm setting the bond at $25,000 plus a GPS device. Do you even have a GPS device? You don't even have that. I don't know what are my orders doing here that aren't being followed. I don't understand. But this was my orders on July 20th of 2023. Thereafter, those are changed. Or
That means the court, I didn't have anything to do.
you didn't, yeah, you're always the first suspect, but you've been cleared in this
I would
one.
like to take credit.
Anyway,
I don't have any notes to explain, Judge.
those were being changed without, and this court had authority over this case and somebody else was changing these.
It was
without-
post indictment.
It was post indictment after I had signed these orders, which are equivalent to an order, which is inappropriate, but we'll figure it out. Anyway, this court doesn't find $5,000. I mean, I put $25,000 up here, but I did this before this indictment shows up.
Right.
And then this indictment shows up, another burglary of a building, which is alleged to have occurred on or about September 17th of 2024, after he was on bond here. Your bond's $100,000 in each case. Plus, you have to have a GPS device as a condition of bond. So this is irresponsible and of your part. Once you are charged with a crime and a bond is set, and you're presumed innocent unless found guilty. But these are probable cause decisions by the grand jury that you probably committed these crimes, which are what we base bonds on, as the probability a crime has been committed. And we use the circumstances of the case and the criminal history. Your first bond of $5,000 is the same type of offense that you post a bond a few months later, you're committing another of the same offense, same type of offense, as though none of this mattered to you. You weren't taking it seriously. You are now. We're going to take it seriously. You can't just keep committing crimes and think that you can just pay a small bond and not that additional information and additional crime commission won't have a bearing on it. It does. So those are the orders. You must have a GPS device, and the bonds are amended to $100,000 each because of your criminal history and the fact that you're committing the same crime after you posted a bond in the first case of a similar matter. Just a few months after that, you're committing the same kind of crime, according to the grand jury. Anyway, that's the orders of the court. Next event, you set these for trial. It'll be set for trial. Thank you. That's what we'll do. All right, next that was Mr. Landry's cases.
Brian has an add-on from earlier this week.
Monte Madison, habitation, a second-degree felony here, and this one's old.
It is. The state, if I may address the court, the state.
Who's on this one? The state?
Mr. Boyd.
Birmingham.
No, it's Mr. Boyd.
Hold on, he's pulling it. There's that case. I mean, these are the hybrid files which you don't accept. Hybrid representation documents.
The state and I have been talking to settle this, Judge.
Yeah, how's that going?
They're fairly well.
What are we gonna do?
I need 2 weeks. The question is restitution.
You got it in 2 weeks.
Yeah, there's co-defendants, and so we're discussing restitution. There is an offer that probably we're going to accept.
All right, just reset 2 weeks, okay? Thank you.